Welcome to Chapter 11. In this chapter, we'll talk about the responsibilities of the hospitality manager for the property that belongs to your guests. So let's get started. We're going to talk about the liability that the hospitality business has for the property of guests that are in the control or that were in the control of the hospitality business. Then we're going to talk about the topic of bailments, which is actually kind of a special category of this larger, more general topic about property's guest liability. And then finally, we'll talk about property that we're not quite sure who owns it and how we're going to handle those items. Let's begin. Here's a list of the topics that we're going to be covering today in a little bit more detail. Okay, so historically, how did the liability for innkeepers work? You may have heard of the term the Bristol Arms or the Frisco Arms or something like that as the name of a hotel. And you may have assumed that the term arms meant that they're hugging you. Maybe it's that warm embrace at the end of the day. Well, actually, no. Historically, the term arms in this context referred to literally weapons, arms that you would wear, say, into battle, your gun, your mace, your sword, something along those lines. That was the arms in that name. And so what they were saying is, if you stay at our hotel, we'll protect you with our weapons if we get attacked. And so really the nature of the innkeeping relationship was in large measure about protecting the guest's stuff. Nowadays we don't think as much about that, but it was a major issue. Think back to the Middle Ages. There wasn't really police forces. It was a dangerous world with highwaymen and brigands of various types. And so traveling between communities, going to a place where you don't know anyone, was a pretty dangerous proposition. And once you arrived at your place, you still weren't necessarily safe. So one of your primary concerns as you approached an inn was, will they be able to keep me safe? And so that's really goes to the heart of this relationship that the guest has with the innkeeper. So historically, how did the common law work? Well, innkeepers were responsible for the safety of the property of the guests. Now, there were limitations. Obviously, there could be a natural disaster, a fire, a lightning strike, a flood, something along those lines that could destroy guest property. There could also be some type of civil unrest, maybe a battle, a war, a rioting, things along those lines. Or, of course, the guest, him or herself, could be negligent in how he or she maintained the property. But generally speaking, the innkeeper was taking on a pretty significant duty to the guest when the innkeeper accepted the guest into the inn. This was a pretty significant obligation, and we have generally moved away from that kind of really, really expansive definition about what innkeepers do. So this is not usually the rule. So I have the word historical here, intentional. This is no longer the standard, but I think it's helpful to consider this when we're considering kind of where we're going from here, because this was so onerous. States have adopted lesser levels of liability. And I have the statute in Texas in the next slide. And this uses what we call the prima facie liability rule. And this means that generally speaking, the innkeeper will be liable to some extent for the losses that a guest has. Okay, so let's go through this. And we're looking at a particular section of the statute. This section applies only to a hotel who continuously maintains a metal safe or vault. So again, this is a hotel that has a metal safe, and keep suitable locks or bolts on the guest's sleeping room doors. So again, these are two relatively common techniques or ways that a innkeeper can preserve the assets of the guest. And so when the innkeeper takes these two sensible actions, then he is going to, or she is going to be afforded additional protections under the statute. If the innkeeper is missing one of these things, either doesn't have the metal safe or doesn't have effective locks on the doors, then he is not going to be eligible for the protections that we're going to talk about in here. These are necessary requirements before we get to this level, okay? But let's assume that our hotel has both of these elements. So then our hotel is going to be able to take advantage of this. A hotel, apartment hotel, or boarding house keeper is not liable for a loss or injury suffered by a guest from the loss of valuables in the amount of more than $50. But we don't have a period here, we have if. So we're going to need to have, I'm sorry, I should put it all the way down here. So this $50 limitation you can see is pretty sweet. This statute was actually written a long time ago, over 50 years ago, maybe even longer than that. So $50 back in the day that the statute was written was probably not a small amount of money, but $50 nowadays is not going to be a significant amount. So you as the innkeeper, you're really getting kind of a break with this $50 liability level if you have these three things satisfied. So in total, to take advantage of this $50 limitations on liability, you're going to have to be able to check off this box and this box, and you're also going to have to check off these three boxes. Let's see what they are. The valuables could reasonably have been kept in the safe. Okay, so we have the safe, we make it available to our customers, but we all know that probably in most cases, the customer or the guest is not going to use the safe. And so it's kind of like, well, hey, we gave you this opportunity, but you chose to keep it in your room and it was stolen. Well, that's kind of your own fault at that point. That's the idea behind this. Now, obviously, if the valuable is a lot larger, for example, a car, or maybe what would be something else that might be larger? An expensive gown, for example, maybe a wedding dress, maybe that wouldn't fit in the safe. There could be things that would not fit. So those would be exempted from this $50 liability. But if they could, then that's going to be limitations on liability. But that's not the only one, because this is an and situation. So we need to have all 5 of these be present before the innkeeper gets to take advantage of this $50 level. The loss or injury does not occur through the negligence of the hotel. So if the hotel is negligent, let's say the hotel housekeeper leaves the door ajar after having cleaned the room, then this $50 limit isn't going to apply even if the guest could have put the stuff in the safe. So this has to be a situation where the hotel was not irresponsible in how it was maintaining the guest's part of the hotel. And finally, we need a printed copy of this section is posted on the door of the guest's sleeping room. This is pretty obvious in most cases because most hotels really just have 2 rooms, the sleeping room, which is obviously where the bed is, and a bathroom. Possibly a closet might be an addition. If it's a suite, there might be more than 1 bedroom, but you have to make sure that it's posted on a sleeping room. There have been cases actually in Texas where it was inadvertently posted, say, on a bathroom, and guess what? The innkeeper wasn't able to take advantage of this protection. So as an innkeeper, you'll want to make sure that all 5 of these boxes, 1, 2, 3, 4, 5, are checked off so that you can be certain that you can take advantage of this $50 amount. And as I noticed before, this is really a very unusually low amount. Most states you're going to have a much higher amount than this. It's not going to be endless. It's not going to be the common law rule that doesn't have any kind of cap. So there will be some cap. It won't be as low as this. So as you move in your career to other states, don't be surprised if this number is significantly higher. So this is from the textbook. This is a breakdown of the things that you ought to think about as you try to minimize your liability for loss that your guests suffer due to property. Again, here the textbook says we need to have a posting notice. And I've just in parentheses here taken the language from the statute. And here again, this language right here is what's relevant to this requirement. And I'm doing this mainly just to show you the Texas law is pretty typical. Yes, we do need to have a posting notice, and not only do we have to have a posting notice, but we know where it needs to be located, on the door of the guest sleeping room. There needs to be a secure safe, and again, we have a little bit more specifics, a metal safe or vault. There needs to be suitable locks on the doors and windows. Again, we have a little bit different definition. There's nothing in our statute about windows, but we do have locks or bolts on the sleeping room doors. Limitations on required possession. We don't have anything in the statute about that. Limits on replacement value of luggage. And again, ours isn't restricted to luggage, but we do have a limitation for everything, the $50. And a penalty for negligence. So if again, the hotel is negligent, that $50 protection isn't going to apply. It's not a protection that the person is going to get. Okay, so anyway, so this is just kind of a reworking of the statute. Most importantly for you, of course, to know is the actual statute that applies to us. This is what I care about you knowing, but this is kind of a helpful way of thinking about what the statute is that we have in Texas. Okay, so we're done with this first topic of liability for guest property. Now we're going to go on to bailments, and this is a special case. We've talked about, really, this first section is what liability the hotel has when the guest doesn't use the safe, when the guest chooses to maintain possession of the item. But let's consider the other possibility, because the guest can give over the items to the hotel for its safekeeping, and we call that a bailment. And let's just look at the definition here. What is a bailment? It's the delivery of an item of property for some purpose with the express or implied understanding that the person receiving it shall return it in the same or similar condition in which it was received when the purpose has been completed. So it's the delivery of the item and the eventual return. Okay, so we have two people. We have the original person who has the item. He surrenders it to, we'll say this is person A. He surrenders it to person B, and then with a passage of time, person B is returning it to person A. This arises in lots of circumstances. This isn't a hospitality-related one, but imagine that my car isn't working well. I might deliver my car to the car dealership for repair work. I leave the car there. Well, at that moment, I have a bailment. Obviously, I actually don't expect the car to be returned in the same condition. I want it to be in a better condition, but that would be an example. I've delivered the car for a purpose, which is repairs, with the understanding that the person receiving it, in this case the car dealership, shall return it to me in that repaired condition once the purpose, the repair, has been completed. I maybe need my watch repaired. That could be another situation. Or dry cleaning. I want to get that dress cleaned. That would be a similar bailment circumstance. Maybe I want to get an item appraised. That could be another circumstance. There's lots of different situations. Of course, in a hotel, many times it's that I want to have this in a secure place. I happen to have some expensive jewelry. I'm staying at the hotel. I deliver that expensive jewelry for the purposes of its being kept safely, with the understanding that the hotel will return it to me when the purpose has been completed, when I'm ready to leave or when I'm ready to use that item. So what are some bailments that exist in the hospitality industry? One would be a coat check. Imagine that there's a room, this used to be more common than it is now, a hat check or a coat check. If you watch old movies, you'll see these pretty commonly. And there'll be a coat check, well, they call them coat check girls. I guess it could be coat check boys as well. And what would happen is you would surrender your coat or sometimes your hat or maybe your umbrella to the coat check girl. She would give you a receipt. Maybe it would be like a number, like a tab, and so she would put the tab maybe in the pocket of the coat, and then she would give you the same number. And so when you returned, maybe after dinner or whatever the event was, maybe it was a party or reception, you would show them the number, and then she would be able to find it because she would have organized the coats and the hats based upon that numbering system. That is a bailment. The coat is delivered to the coat check girl who works probably for the hotel or the restaurant, and it's supposed to be returned in the same or similar condition when the purpose is completed, when the guest has had the meal or whatever. Sometimes these arrangements were free, that the coat check function was, kind of part of the price that the person was paying to enjoy the event. Although many times the coat check girl, there was an expectation that she would be given some kind of tip So it wasn't completely free, but it wasn't a requirement. Then there were other times where maybe the coat check wasn't free, that the place would need, that the person would need to pay some relatively small charge to have their items stored safely. Let's say that you go back to the coat check area and your coat isn't there. Well, guess what? You can sue them for that. Or let's say you return, your coat's there, but there's a big stain on it. Again, you could sue under those circumstances. So coat checks is one example, probably less common today than once was. But one thing that's probably more common today is valet parking. You're going out to a fancy restaurant in maybe downtown Dallas. It's very hard to park. If you do park, it's going to be maybe far away from the restaurant, and maybe it's not necessarily the safest part of town, and it's late at night, and so you are uncomfortable walking to and from. Well, a good solution is hiring or using the valet service, which is oftentimes right outside the restaurant. You pull up in your car, you give the valet your keys. He will give you some kind of token, usually, that indicates that, that's your receipt to return when you are wanting to get your car back. And then the valet has some place that it parks. And again, when you return, you will collect your car. You'll very likely tip the valet, and there may or may not be a charge associated with it, depending upon the particular arrangement for the hotel. If the valet steals your car, or if while he's parking it or bringing it back, he damages the car, you can sue. Again, a bailment situation. Safety deposit boxes are another example. Just safes generally would be an example. A laundry that you turn in at maybe a dry cleaning business that you turn in your clothes, another example. And of course, many times hotels do provide laundry services. It could be dry cleaning, but it could be traditional laundry. Luggage storage. Maybe your room is not available for you when you first arrive. The hotel may agree to store your luggage until the room becomes available. So these are some examples of bailments that are related to the hospitality industry. Something that wouldn't be available would be an unattended storage place, because under those circumstances, there is no one who is receiving the item, again, because it's unattended. Yes, I could put my coat on this coat rack and go eat, and when I return and my coat's not there, because a bailment never existed, because no one ever accepted the bailment, I'm going to be out of luck under those circumstances. Now, we talked before about the limitations on liability, this statute, but you may have noticed that it was really just talking about the hotel type situation. It's not focusing on restaurants. Oh, I went too far, sorry about that. It's not focusing on restaurants or bars. So unfortunately for restaurants or bars, they don't get to benefit of this limitations on liability. But in a way, it kind of makes sense, because if you think about it, most of the time when you go to a restaurant or bar, stuff that's valuable to you, you're going to keep with you. Your necklace, for example, your watch, your phone, your purse, your wallet. Yes, I suppose you might have some fancy coat that you might put in a coat room, but for the most part, you're probably going to keep those items with you. You're not going to be checking them. And so there's going to be less situations where you'll actually have significant things of value that are not covered by those limitations. And so there is less of a bailment issue in those circumstances with restaurants and bars, but they can arise for sure. Okay, so we've looked at the term bailment, and we had person A who surrenders the item to person B, and then person B ultimately returns it to A. This first person is called a bailor. And again, this is this pattern that we've seen in previous vocabulary, where we have a word that ends OR, and we say this person does the bail, or does the bailment. And then we have B here, and this is the bailee. And he or she, the bailee, receives, because the EE ending is the receiver, receives the bailment. Another example of this would be the donor donates, makes the donation. The donee receives the donation. or the promisor makes the promise, the promisee receives the promise. So it's the same pattern. It's the same pattern, but I will promise you that it's very easy to get confused on this. I would say this is a very commonly confused word. People will think that the bailor is the hotel, but the bailor is the guest. I think the reason that people make that confusion is that this seems like this ought to be the active party in the story, when really the bailor is the passive party. The bailor surrenders it, and then it's the job of the bailee to keep it safe. It's the one that's having to worry about, hey, where is it? Where is it? Is it safe? Is it safe? And yet we usually think about the EE person as being in a more passive position. Just, again, consider what the OR and the EE mean in the context, and hopefully that'll point you in the right direction. So what is the bailor? A person or entity who gives property to another in a bailment arrangement. And again, here in the hospitality industry, the guest who owns the item that's going to be entrusted would be the bailor. And again, the next slide. The bailee is the person who receives it and holds it. And again, the hospitality business will be the bailee. The hat check girl is the bailee. The clerk who accepts the diamond necklace to go into the safe at the hotel is the bailee. So remember this. I'm going to put a big star here because this is a common one for people to get confused about. Here's an important point. The liability of the bailee, and again, in this case the hotel, may be limited if the bailee can prove that it exercised the required standard of care. So the bailee isn't an insurer of the item. Things can happen. The building can burn to the ground. And guess what? Things in the safe may have been destroyed. That's not necessarily going to mean that the bailee is going to be responsible. So it's not a situation where the bailee is always going to be responsible just because something has gone awry. Let's consider the situation of gratuitous bailment. You've probably heard the term gratuity. Yeah, here we go. We all know a gratuity is a tip, right? This is what you might give your waiter or waitress if they've provided you good service at a restaurant or whatever. And the reason we call it a gratuity is that it's not required that this be provided. If I pay my bill but leave zero money in tip, I can't be charged with running out on the tab because this is a freely given amount. And that's the nature of the term gratuity. We can also see it in the word grace, the idea that this is something freely given. So a gratuitous bailment is a bailment that is given with no payment being involved. Going back to the coat check scenario or the safe scenario in the hotel, those are almost always offered nowadays for free. The bailee isn't going to get any compensation for providing the bailment. The bailor is in some sense getting a free ride. These are very common. And again, doesn't really change the fact that the bailee is going to be responsible for maintaining the safety of whatever item is in that particular bailment. We can divide up bailments into three categories. We have bailments that are for the benefit of the bailor. Again, keep in mind the bailor, this is the guest in many cases, although the example I have is a little different. Let's imagine that you have a worker who is painting some of your hotel rooms. The worker is an independent contractor, and the worker says, hey, would it be okay if I leave my ladder and my drop cloths and my paintbrushes here as opposed to having to cart them back and forth every day? You say, well, sure, why not? And so you allow the worker, in this case the bailor, to leave his items with you, and yeah, you have become the bailee. How is this relationship benefiting you, the bailee? Not very much, probably, but it's benefiting the worker because he now doesn't have to lug those items back and forth. So sometimes the bailment just really benefits one party, the bailor, but it can be the other way. It can be such that it benefits only the bailee, only the person receiving the items. So imagine that you have a good relationship with another hotel or business in the area, and it has some equipment that you want to use for a particular event. you might ask to borrow their item and use it for that particular event. Maybe they've got, a karaoke machine set up or whatever, and they are gracious enough to let you use it. Maybe you've let them borrow something from you from time to time, and so you're borrowing it for that event. Well, it doesn't really help the bailor under those circumstances. In fact, the bailor is at a disadvantage because it doesn't have the karaoke equipment right now. The bailee is getting the benefit of the use of that particular item. So that's another way it can work out, but probably the more common way is for both parties to benefit. And sometimes the benefit of one party might be a little bit more subtle. So again, let's imagine that you're offering a valet service. Let's say it's a free valet service. You are doing that not because you're just super nice, right? You're doing it because you think it meets your business needs. Maybe there's limited parking in the area and you're worried that potential guests will not stay at your hotel if there isn't available safe and dependable places to store their vehicles. And so by offering the valet service, you hope, well, this is a restaurant, but this would also work in a hotel situation. You hope to attract more guests, and you also, and what is attracting more? So that's good for you to have more guests in your establishment, more profit for you. But it also benefits the guests, obviously. They are going to experience greater convenience. That's why it attracts them, right? So the diners or the hotel guests, they are the bailors. And you, the business owner, are the bailee. You're both benefiting. It's a win-win, in other words. Let's talk about infrahospitium. I'm not sure how that's actually pronounced. That's how we'll call them anyway. Infrahospitium. That's a Latin phrase that means within the hotel. I guess hospitium is an old-fashioned word for a hotel, and you can see in the word hospitium, like the word hospitality is kind of obviously connected to that. We've already talked historically what that obligation for the hotel owner is, for that innkeeper. The hotel owner would be liable for the guest possessions that are within the hotel that are infrahospitium at the time of the loss. Again, we talked about that expectation back here, right, on slide 4. But as we've said before, the court looks to this, not so much the infrahospitium idea, but to bailment law or negligence law. And again, we have here a discussion about liability or negligence. Okay, so now we're going to, wait a second. Now we're going to flip to our third topic. We talked about bailments. And now we're going to talk about property with unknown ownership. We have three categories to look at here. We have mislaid property, lost property, and abandoned property. I think most of us know what abandoned property means. That's pretty obvious. But mislaid and lost, sometimes we use those terms interchangeably, but in the law we have a somewhat different meaning associated with it, and you are responsible for making the distinction. So we're going to kind of go through the differences here. Okay, so mislaid property is when I put something aside on purpose. I want to put it in a particular place, so it's on purpose, and then I forget about it. Right, so maybe I put my coat in the coat check place, and then I forget about that I've done that, and so I don't remember to go back and get it. That would be a mislaid item. I didn't accidentally put it in the coat check place. I intended to do so. I was successful at doing so. That's a mislaid item. So we have two aspects. I put it aside on purpose, and then I forgot about it. And you can see how that coat check area wouldn't necessarily know who I am. I mean, I may have filled out something that gave information about me. Maybe if I'm staying in the hotel, I had to give a room number, and so that would give leads. In that case, the hotel can reconnect me with the coat. But let's say all they gave me was a receipt, and I'm supposed to come back and present that, but I never do that. I never present that item. Well, what are they supposed to do with the coat? They can't find me, and so it is considered mislaid property at that time. An example, could be an umbrella, that I leave that in a particular place, maybe that the hotel has for storing umbrellas, or again, maybe the coat check place. So what is the obligation that the hospitality business has? It has to keep the item safe until the owner claims it. We'll talk more about the time frame for this, but it's not just a day or two. The owner might not realize it's missing until the next day it rains, right? And so that's when he's like, where's my umbrella? And it may take him a little while to think through where that umbrella might be. So that's what mislaid property is. But let's distinguish mislaid property, which is put aside on purpose and then forgotten, from lost property. This is also forgotten. So our second item is the same. But instead of it being put aside on purpose, this is inadvertently put aside. So going back here, oops, wait a second, it went the wrong way, I apologize. Here we go. So this is, we'll call this condition A, and we'll call this C. Here we have B and C. So, but in both cases with mislaid and lost property, it is forgotten by the owner, but how it came to be put in the position it is in varies between mislaid and lost. Mislaid is intentionally put in a place and then forgotten, and lost is inadvertently put in a place. Okay, so what are we going to do? Well, lost property, of course, can be anywhere. I put down my keys and walk away. It could be between the cushions of a sofa. It could be in the ladies' room or men's room, lots of different places. If it's mislaid, it's more likely to be, in a particular assigned place for it. So it's more likely that you'll have lost property that hotel employees kind of stumble upon. And when this happens, you need to have a procedure that the employees know to follow. The old expression, finders, keepers, losers, weepers, there's a bit of truth to it, but it's not automatically the truth. When you find something, especially in a hotel or restaurant circumstance, it does not belong to the finder at first. It might eventually, after the passage of many, many weeks, belong to the finder, but right now it doesn't. It's the obligation of the hotel and therefore the employees to turn over those items to a central place so that they can be hopefully reunited with the true owner. Again, there will be a process, a lost and found log. This will be kept in a secured place. There might be efforts, if it's reasonable in the circumstances, to try to find out whose this might be. Maybe there are some identifying marks on it or some context clues that will help us figure out who it is. But in most cases, you're just going to hold on to it, and many times, maybe even most times, the employer will come back, the owner will come back and say, hey, I think I might have left my phone here. Has anybody seen a phone with these particular characteristics? I think I would have left it in this particular place 2 days ago. And again, obviously, if the owner comes back, then you're able to award it to the owner. But let's say the owner never comes back. Well, some hospitality businesses will allow that finder, that employee, to get the item. He or she will be rewarded with it. Some don't. Some maybe donate it to charity or some effect along those lines. Now we have our last category. Okay, so this is, we share this with the mislaid. One second here. Get my mouse. Here we go. So this is similar to mislaid in that it's put where it's put on purpose, but in this case we don't have anything being forgotten. The owner doesn't plan on coming back. So this is, and if you were to do a continuum, we have abandoned over here. We have mislaid, which has some characteristics with abandoned, this first characteristic. And it has some characteristics like lost, the fact that both were forgotten. So both of these are forgotten, and both of these are intentionally set aside. I can help you keep track of that. So let's say that you know an item is truly abandoned. Just no doubt about it. The person, maybe the owner actually says, I don't want this. Well, then there's no need to seek out that owner. There's no need to try to reunite that person or put it in a lost and found, because it isn't lost. It isn't mislaid. It's not, the owner doesn't want to own it anymore. Many times, though, you can't be sure that it's abandoned. I mean, even if you find something in the trash can, sometimes people accidentally throw things away. Maybe they had a lot of things in their hands and they added something to that they didn't intend to. So when there is a doubt, you should assume that the item is instead mislaid or lost and go ahead and follow the usual patterns. But if you are confident that it truly was abandoned, then there's no need to go through those steps. Okay, so how are you going to handle lost and found type property? Well, the first thing is you want to check your state's laws to see what you are required to do under those circumstances, both with things that have been bailments and things that haven't been bailments. You're going to want to have your employees turn in all lost property or mislaid property so that it can be accounted for. You'll want to keep some kind of lost and found logbook. How you actually do this may vary depending upon the requirements of state law, and actually how that functions as a book is going to also be an issue and dispute. Is it really going to be a paper book, or is it going to be some kind of online system? Maybe you'll have to take photos and log that into some kind of database or something like that. Of course, if the item is relatively trivial, say a used paperback, you're not going to be up all night worrying about it. But if it's something of significant value, like a cell phone or a piece of jewelry, then you will want to try to find the owner. And again, as always, whenever we're dealing with things in liability, you'll want to document those efforts. You'll want to say, called Mrs. Green, whom we think might be the owner of the item, and left a voicemail telling her that we had found this item, or contacting all of the rooms on the 5th floor where the earring was found, or something along those lines, to document that in the event that later on, after you have disposed of the item, the owner says, hey, why did you dispose of it? It belonged to me. Well, then you can refer back to your efforts to find the person. You'll want to hold the items for a particular time. Again, it's going to vary on state law, but 60 days is a good rule of thumb. You're not going to want to sell it or allow the employee to have it until at least 60 days pass. You want to make sure that when you return the item to that purported owner, that you have a system in place to make sure that that really is the owner. You could have an overzealous employee perhaps send a friend in to claim that it's my cell phone or something along those lines. So you're likely to want to have a process in place to confirm that it's that person's possession, and maybe to document, maybe take the information of their driver's license or take a picture of it, so that in the event that it ends up somebody else later on comes and says, hey, wait a second, no, that wasn't theirs, that was mine, you can track down that person who perhaps has essentially stolen the item. And again, if the person doesn't come forward within the 60 or whatever days, then you'd want to dispose of the item according to your written procedures. And again, it may be give the item to the employee who found it, but maybe that employee is no longer with your organization, or maybe that's not your policy, so perhaps it might be donated or sold, along those lines. So just be sure however your policies say you ought to handle it is in fact how you do handle it. So this concludes our presentation on Chapter 11. I hope that it has been helpful for you. If you have any questions about it, of course, as always, please email me, or you're welcome to stop by my office hours so we can discuss the material in more detail. Again, thank you for your attention, and I hope that you have an awesome day.